Hello and welcome to Courts Today by LiveLaw. Let's get to today's top legal news. In the plea alleging fake encounters in Assam, the Supreme Court has said that only issue is whether PUCL judgment guidelines were complied or not. Supreme Court has observed that wife separated from first husband can claim maintenance from second husband though first marriage not legally dissolved. While denying bail to an accused, Allahabad High Court said that a minor rape survivor in our country would rather suffer silently than falsely implicate someone. In the wet student death case, the Kerala High Court has stayed readmission of accused students at Mannuthy campus. Supreme Court has directed making Chandigarh UT a party in ex-Punjab CM assassination case Convict's plea for transfer from Tihar jail. I am your host Syed Amir Hussain with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the very end and do not forget to like, share and subscribe to our channel because your support means the world to us. The Supreme Court bench of Justices Suryakant and N. Koteswar Singh was hearing a case raising the issue of fake encounters in Assam. The plea has been filed by an advocate from Assam, raising the issue of encounters by police personnel in the state. The petitioner claims that more than 80 fake encounters took place between Assam police and persons accused in different cases since May of 2021. He seeks an inquiry by an independent agency like the CBI, SIT, or a police team from other states. He approached the Supreme Court after Guwahati High Court order dismissed his PIL raising the same issue. According to the High Court, no separate investigation was required into the alleged incidents as state authorities were conducting investigation in each case. The Supreme Court had earlier sought data on any inquiry initiated by the Assam Human Rights Commission into alleged fake encounters and emphasized the need for proactive action by human rights commissions in civil liberty cases. During the hearing, Advocate Prashant Bhushan, representing the petitioner, stated that 171 fake encounter cases had been filed in Assam in recent years, with gross non-compliance of guidelines laid down by it in the case of PUCL versus State of Maharashtra. He highlighted that these guidelines also apply to grievous injury cases in police encounters, calling the encounters a menace. He alleged that FIRs were often filed against victims and proposed an investigating committee led by a retired judge. He also informed that Assam had failed to submit the affidavit on the status of encounters despite the court's directions. On the other side, Solicitor General Tushar Mehta argued that the PUCL guidelines had been fully complied with and claimed that certain critical aspects had not been brought to the court's attention. He sought an opportunity to present the petitioner's background and assess the credibility of the allegations. At the end of the hearing, the bench indicated that the only issue to be considered is whether the guidelines laid down by it in PUCL versus State of Maharashtra were complied with or not. The Supreme Court ruled that a woman is entitled to claim maintenance under Section 125 of the CRPC from her second husband, even if her first marriage was not legally dissolved. Holding this, a bench of Justices B.V. Nagaratna and Satish Chandra Sharma granted relief to the woman, allowing her appeal against the Telangana High Court's order to deny her maintenance under Section 125 CRPC from her second husband just because her marriage with her first husband was not legally dissolved. In this case, the second husband was aware of the wife's first marriage. The couple lived together, had a child, and later separated due to matrimonial disputes. The wife then sought maintenance under Section 125 CRPC, which was initially granted by the family court but later set aside by the High Court. The second husband opposed her plea for maintenance, contending that she can't be considered as his wife because she had a legally subsisting marriage with her first husband. Setting aside the High Court's decision, the top court has now observed that there is no bar under Section 125 CRPC for the wife to claim maintenance from her second husband, even though her first marriage was not legally dissolved. The second husband opposed her plea for maintenance, contending that she can't be considered as his wife because she had a legally subsisting marriage with her first husband. Setting aside the High Court's decision, the top court has now observed that there is no bar under Section 125 CRPC for the wife to claim maintenance from her second husband, even though her first marriage was not legally dissolved. The court said that since the second husband was aware of her first marriage when he married and remarried her, therefore, he could not take an excuse to deny her maintenance just because her first marriage was not legally dissolved. The court clarified that a formal decree of dissolution is not mandatory if the woman and her first husband mutually agreed to separate. The absence of a legal divorce does not prevent her from seeking maintenance from her second husband. It also emphasized on financial vulnerability of homemakers in India to reiterate that the right to maintenance is not merely a benefit for the wife, but a legal and moral duty of the husband. Accordingly, the appeal was allowed and the maintenance award granted by the family court was restored. Denying bail to a man accused of raping a minor girl, the Allahabad High Court has observed that in our country, a minor girl who is a victim of sexual aggression would rather suffer silently than implicate somebody falsely. A bench of Justice Sanjay Kumar Singh said that the court must keep in mind, while appreciating the evidence of the prosecutrix, the values prevailing in the country, particularly in rural India, where it would be unusual for a girl to come up with a false story of being a victim of sexual assault to implicate an innocent person. The court was hearing a bail plea of a man accused under the Bharatiya Nyaya Sanhita or the BNS and the PUCL Act for allegedly raping an 11-year-old girl. He was arrested in September last year and sought bail, arguing that the victim's statement did not clearly mention penetration. He claimed that since there was no sexual intercourse, the offense of rape was not made out. He also pointed to the medical report, which showed no signs of force, arguing that the case was not supported by medical evidence. However, the state opposed the bail, stating that the victim's father witnessed the incident inside their house. The prosecution argued that the victim had described the incident in detail and accused the man of outraging her modesty, which falls under the definition of rape. It was also pointed out that under Section 29 of the POCSO Act, the court should presume the accused is guilty unless he proves otherwise. The court found minor inconsistencies in the victim's statements, but said they would not weaken the case. Regarding the argument about penetration, the court ruled that the accused's actions went beyond just an attempt and amounted to rape under Section 63 of the PNS. The court added that even if, for the sake of argument, it was assumed that there was no penetration, even then, the accused was liable to be punished as the victim was aged below 12 years, as the alleged act of the accused is covered by the definition of rape provided under Section 63. Thus, the court refused to grant him bail. The Kerala High Court's division bench has stayed the order of a single judge that allowed the readmission of 18 students accused in the suicide case of veterinary student Siddharthan JS. Siddharthan allegedly died by suicide on February 18, 2024 due to ragging and assault at the College of Veterinary and Animal Sciences, Wayanad. In December 2024, a single bench had cancelled the expulsion of the 18 students accused in the case and allowed them to rejoin the Mannuthy campus, and also directed a fresh disciplinary inquiry against them. Siddharthan's mother challenged this decision by filing a writ appeal. The division bench of Justice Amit Rawal and Justice K.V. Jayakumar has now allowed her to appeal and ruled that she must be heard during the fresh inquiry. While staying the single judge's order, the court strongly remarked that students involved in ragging are worse than those involved in vandalism. The Supreme Court has said that the Union Territory of Chandigarh must be made a party in the petition filed by Jagtar Singh Hawara for transfer from Tihar jail to any jail in Punjab. He was convicted in the 1995 assassination of former Chief Minister of Punjab, Beant Singh, and 16 others. 15 accused were convicted, out of which 2, including Hawara and Balwant Singh Rajwana, were sentenced to death, while others sentenced to life imprisonment. All other co-convicts are lodged in Punjab, and he is the only one lodged in Delhi. And so, he has filed a petition to be transferred to Central Jail in Punjab. In September last year, a bench of Justice B.R. Gavai and K.V. Vishwanathan issued notice in the transfer petition, in which it has been stated that as per the Punjab Prison Manual rules and the Punjab Prison Rules, the petitioner was bound to stay at a central jail of his own state. It has also been pointed out that no case is pending against the petitioner in Delhi. Other grounds raised in the petition are that his conduct in jail is good. The crime took place in the background of serious social upheaval. His daughter resides in Punjab and he is unable to attend court proceedings that are pending in one case. The court noted the necessity of the Chandigarh administration because Hawara was tried and lodged in Budhel jail in Chandigarh, from where he was subsequently shifted to Delhi. So, the petitioner has been asked to implead the UT administration as a party. The court has directed the NCT of Delhi and Union to also file a reply along with the Chandigarh administration within 4 weeks.